remarks of the President on the 50th anniversary of the first Workmen's Compensation Act from the South Lawn of the White House, August 31st, 1961.
Mr. Vice President, Governor Freeman, Postmaster Day, and members of the Cabinet, I want to express our great pleasure at being here this morning and having this opportunity to salute the state of Wisconsin, the state legislature of that state, for the action it took in 1911, 50 years ago, in passing the first state workmen's compensation law. And the leadership shown in that state on that occasion was followed in later years by other actions which that state took in the 20s, which led directly to the passage in the 30s of the National Social Security Act. This first step to provide security for American working men who may have been injured, to provide security for their families if they may have been fatally injured, represents one of the great landmarks of social legislation on our books in the long history of this country. That promising beginning has meant security to millions of Americans, and it represents the kind of forward-looking action on the state and national level, the need for which faces us in our own day in 1961. We look back today, but we also look forward, and we recognize that in our time, in the states and in the national government, there is still a good deal of unfinished business. To provide more security for our younger people who want jobs and can't find them, to provide more security for those who are unemployed, for those particularly who are unemployed chronically and who have families who depend upon them, who exhaust their unemployment compensation, who have exhausted in recent weeks the emergency unemployment compensation, and who now want to work and find themselves having to turn to inadequate public assistance. And we also recognize the great need that lies before us to deal more satisfactorily with the questions of health in our society, most particularly and immediately for the health of our older citizens, those who are chronically ill, those who come to the end of their lives, their working lives, with inadequate resources stored away, in spite of many years of devoted labor, inadequate resources to meet their medical bills. I believe it is the national responsibility in the 60s and the national opportunity, as it was the responsibility and opportunity of the Wisconsin State Legislature in 1911, for us to meet this problem of medical care for our older citizens and better medical care for all our citizens. So I want to congratulate the Post Office for this memorial to progress. I'm delighted that the governor, a distinguished governor and progressive governor of the state of Wisconsin, to which we all owe much, that he has come here today and participated in this ceremony. And I'm sure that his presence here, this stamp, that when all of us look at this stamp and put it on any letter or see it in any letter we receive, that we will remember that we also, in our time and generation, have as great an opportunity as the state legislature of 1911, and we mean to take advantage of that opportunity and meet that responsibility in the areas I've described. I'm grateful to all of you for coming today.
Just waiting for the green light here. Okay, thank you for your patience, and we'd like to welcome you on behalf of the Wisconsin Institute for Public Policy and Service to the University of Wisconsin Marathon County campus and to this wonderful building, the UW Center for Civic Engagement, for tonight's forum, The Great Compromise, Lessons Learned from a Century of Workers' Compensation, 1911 to 2011. My name is Eric Giordano, and I am an Associate Professor of Political Science here on campus and Director of the Wisconsin Institute for Public Policy and Service. I would especially like to welcome tonight our panelists, our city and county leaders, business leaders, labor leaders, and other dignitaries here tonight. This forum is being co-sponsored by the Center-Right Coalition of Wausau, and in just a moment I will introduce Keen Winters from the Center-Right Coalition for an announcement of an upcoming event. Other important sponsors and endorsing organizations are noted on the first page of your commemorative booklet, and we would like to thank each of them for their support, which has made this evening's event possible. We would also like to give special thanks at this time to the event planning team consisting of Jim Lawrence, Professor Emeritus of History here on campus, Associate Professor of History Brett Barker, who will also moderate tonight's event, Keen Winters from the Center-Right Coalition of Wausau, and Brad Zweck, the UW Marathon County Foundation Executive Director. And at this time, I'd especially like to take a moment to recognize Brad. Brad has had a personal passion for the importance of this centennial celebration and was in fact the co-organizer of a national centennial celebration that took place in Madison in August. Our event tonight, in fact, is a spin-off of sorts of that wonderful celebration. And Brad not only suggested the event tonight, but he single-handedly put together the wonderful commemorative brochure or booklet that you have in your hands. We'd like to thank Brad very much for that effort. Tonight's forum would also not have been possible without the hard work of WIP's Program Assistant Connie Nicolai, our Research Assistant Ian Reese, our Room Coordinator Chris McCaslin, and AV Tech Director Chris Berg, our University Room Coordinators, our Food Service staff, including Jane Stencil, and our custodial staff. We'd also like to thank Dean Keith Montgomery and the campus for their generous support of the Wisconsin Institute and for the innovative programming that we try to create here. I'd now like to welcome Keen Winters, coordinator of the Center-Right Coalition of Wausau, for an announcement.
Thank you, Eric, and hello, everyone. I just wanted to make a brief announcement about future events. When we have our next future events, we're turning our attention to a topic that I think is on everyone's mind, jobs and job creation. And here's a question for you. How would you like to work for a company that is owned by a foreign company? Probably your reaction to that is mixed, but think of it this way. If you work for a company that's owned by a foreign company, they probably have a global market, and they have a global market strategy, and your job is probably safer. So on September 27th, we're bringing in David Ward to talk about direct foreign investment and how that can help Wisconsin be a better part of the global economy. The event will be held at the Marathon County Public Library from 6:30 to 8:30 p.m. on the 27th. Everyone's welcome, and the event is free. So please come. Thank you.
Okay, thank you, Keen. And also at this time, I'd like to briefly announce that we'll be holding another conference on October 6th. There's a brochure that's available in the foyer. That will be called Positioning Central Wisconsin to Better Compete in the Global Economy. We're bringing in a number of CEOs of Wisconsin-related businesses, and I think that should be an exciting event as well. Tonight's presentation will be followed by an audience question and answer session. You'll be free to ask questions directed to one or all of the panelists. Staff will circulate the theater with microphones. One question per person, please, we would advise. And comments from the audience will be limited to 1 minute. Comments from the audience will be limited, and we will kindly ask you to not engage in grandstanding and that you direct your questions to the panelists. We also ask that you accord our guests and each other with the type of civility that we try to engage in here at the UW Center for Civic Engagement in respect to civil dialogue generally. At the conclusion of the panel, We'd like to invite you to attend a brief reception in the foyer, in the room just outside the theater, where we will have a commemorative cake that we'll be cutting in celebration of the 100th anniversary of workers' compensation, and be able to chat for a little bit with some of our panelists. Just before that, we will have a special announcement by the dean of the campus, Keith Montgomery. So we'll, at the point in the program, we'll turn it over to him. At this time, I'd just like to offer a brief confession that until I was involved with the organization of this event, I really didn't know that much about workers' compensation, especially how it operated. And what I know now is that in a world where industry and organized labor, Republicans and Democrats, Tea Party patriots, and high-minded progressives often seem miles apart, workers' compensation remains a beacon of compromise and a model for how complex issues such as the health and safety of workers and the productivity of businesses can successfully be addressed. Although it was controversial when it emerged on the national scene, to some extent it has withstood the test of time. It's our hope that in presenting this panel today, that we'll receive some insight into how a compromise into an issue that affects all of us can be achieved and maintained, even in a difficult political climate. So without further ado, I now turn the time over to our moderator, Dr. Brett Barker, Associate Professor of History here at Marathon County. He's a scholar, a friend, and one of the few people I trust with my historical emergencies. Dr. Barker.
Thank you, Eric. I trust we won't have any historical emergencies this evening. I would just like to say, as Eric did, that we're here tonight to celebrate the 100th anniversary of workers' compensation, the first bill of its kind in the United States passed by Wisconsin a century ago. It might give some of us a moment of pause to realize that that clip that you saw of President Kennedy was when workers' compensation was half as old as it is now, 50 years ago. So we want to talk about it, though. You've seen what he said in 1961. We want to talk tonight about what the view looks like from 100 years beyond in 2011. So what I'd like to do is introduce the members of the panel. Each of them will then engage in introductory remarks, partly based on their own expertise in the fields of both labor history and workers' compensation. And then we might have a brief exchange or two, depending on how the time is, and then we would encourage you to ask questions. And then we will hopefully have an interchange amongst everyone here tonight. James Buchan is an attorney and serves as chief lobbyist in his position as vice president, government relations and membership for the Wisconsin Manufacturers and Commerce Association. He graduated from UW-Madison with a bachelor's degree in history and later also earned a law degree. He currently serves as a management representative to the State Unemployment Compensation Advisory Council and the Workers' Compensation Advisory Council. John H. Jones, Jr. is a retired senior vice president for Nationwide Indemnity, a subsidiary of the Nationwide Insurance Group. He holds a bachelor's degree in business administration from UW-Oshkosh, and he too received his law degree from the University of Wisconsin-Madison. In addition to a long career with Wausau Insurance, he has served on the board of directors of the Workers' Compensation Research Institute from 1983 to 98, and again from 2002 until his retirement in 2006. He also served on the Wisconsin Workers' Compensation Advisory Council from 1980 to 1992. Ron Kent is a retired AFSCME International Education Representative for Wisconsin. He was employed in that capacity for 30 years, providing labor education and training to over 60,000 AFSCME members and leaders, and served 3 years as a field representative of AFSCME Council 24, providing arbitration, unemployment, worker compensation, and civil service representation to 3,000 state employees. Kent received a BA in economics and a master's degree in industrial labor relations from the University of Wisconsin-Madison. He is author and co-editor of Culture, Gender, Race, and U.S. Labor History. He is currently a member of the labor team of the Wisconsin Workers' Compensation Advisory Council. And finally, Andrew Kirsten is the Frankenthal Professor of History in the Department of Democracy and Justice Studies at the University of Wisconsin-Green Bay, where he teaches courses on modern U.S. and labor history. He received his Ph.D. in American History from the University of Cincinnati in 1997. He is the author of several books on U.S. labor history and U.S. labor leaders. His latest books are entitled Clarence Darrow, American Iconoclast, and The Battle for Wisconsin, Scott Walker, and the Attack on the Progressive Tradition. So without further ado, let me welcome James Buchan to the podium.
Well, thank you, and it's a pleasure to be here tonight, and I want to thank the Institute and the various sponsors for hosting this event. This is obviously an important place to be to talk about workers' compensation in the centennial year of the program, inasmuch as the first policy for workers' compensation was issued by a Wausau insurance company, the Wausau Insurance Company, to a Wausau employer, what is now known as Wausau Papers. And so the history of this program, both in our state certainly and nationally, is very much intertwined with this very community. And I think, as I say, this makes it a fitting place to have such a program. Workers' compensation was one of the numerous progressive era reforms that were pioneered, really, in many cases in Wisconsin. Some of them really generated a lot of considerable consternation among the business community in this state. And it was out of that the organization that I worked for, the WMC, was formed also in 1911, the same year that the workers' compensation law was passed. Things like the nation's first personal income tax were adopted that year, and it got a lot of the folks that ran the larger companies in our state pretty excited, and they thought that we better organize an entity to speak to the legislature and to try to address these issues and perhaps talk to the populace about our views on some of these progressive reforms. And because it's our 100th anniversary also, I was looking through the minutes of the founding meetings of this organization, and you find very flowery statements of concern about the radical legislation being considered in Madison and in some cases. But if you continue to look at these documents, you find that there was a very different tone expressed about the workers' compensation proposal. And in fact, they lay claim to having contributed many of the provisions of the law and having worked closely with their counterparts in the labor movement to craft a compromise that ultimately became the law that, or at least the roots of the law that we know today. Some of these companies that formed this organization, again, that I worked for and that were involved in this are familiar to us today, like Kimberly-Clark, the J.I. Case Company, Pabst Brewing, Schlitz, Alice Chalmers. Some of these have gone out of business, but I think some of us are old enough to remember them. Bucyrus and the Manitowoc Company, to name just a few of them, a lot of the bigger manufacturing employers in our state. And what was attractive to them, and I think that what ultimately made this program a success and has made it an enduring success is really the fact that it really was a balance. It had something for everybody. It's what we would kind of call now a win-win situation, which they don't very often exist. But in the context of what was going on at the time, there was something in this for employers just as there was for employees, and both of them benefited from the adoption of this program. And it was for that reason, I think, that the manufacturers were engaged and organized labor was engaged, and that the program has endured to this day. The great compromise really is that employees gave up their right to sue in tort, to sue for damages, if you will, when they were injured on the job. They could not sue their employer if they were part of this program. And for the employer, that protection, in exchange for that protection, they gave up the right to find fault with the employee if they got injured on the job. It was a no-fault system. There was just automatically going to be benefits if you were injured on the job, regardless of the cause, regardless of who caused it or what caused it. You were going to get a benefit that was hopefully sufficient to tide you over the temporary disability or perhaps longer-term disability. So both sides got something out of the deal, and I think that was the hallmark of what made it come together. I think there are a lot of other features of what they developed at the time that have endured and have really made this something that continues to be a program that is I think beneficial to society, beneficial to injured workers, and beneficial to employers. And some of those include things like the fact that it was a program built on private insurance. It wasn't a government program per se. The insurance aspect of it, the benefits that are provided are actually provided by private insurance companies. And I think that made a difference in terms of keeping costs down and keeping the program operating more simply. The program has succeeded in maintaining itself as the exclusive remedy. In other words, we haven't sort of figured a way around it so we can still sue the employers if somebody's injured on the job. And that's been an important thing to fight to maintain, frankly, and it's something we've had to fight to maintain. We've been able to keep transaction costs low in the system. The program was set up to be sort of self-affecting. If a person was injured, the idea was that they should be able to get those benefits easily and quickly, without a lot of dispute, and hopefully without any lawyers involved. And that really has held up pretty much to this day. I mean, there are complex cases that lawyers get involved in, but many of the routine claims are handled without the involvement of lawyers and really keeping the transaction costs, if you will, very low. The program had the broader benefit, I think, of promoting safety in the workplace. If you read the track that's in the brochure that the program is in, they describe the working conditions of the early 20th century and some of the sort of attitudes that I think employers in some cases had about workplace safety. And this program really had the effect of promoting the concept of trying to improve workplace safety, both as individual companies, but also as industry-wide efforts took hold, because the more you improve safety, the less this program was going to cost you. And that has, I think, held up to this day to the point where we've seen the actual incidence of injury and certainly death, work-related deaths decline quite dramatically, certainly in recent years. The program has also managed, in this state anyway, to involve relatively low levels of healthcare utilization, and that's been something that's important to keeping the costs down. In other words, you get good quality care, but we don't have sort of excessive care. We don't have people, really more or less the healthcare providers milking the system for their benefit at the expense of those that are paying the bills, and that's been something that we've worked to preserve in this system and has held up quite well. And then again, more recently, I think the concept of return to work has taken hold in our state perhaps better than in most places. And what this is really about is the observation, I think, that everybody who's ever studied the situation agrees with, that you're better off working, you're better off going back to work as soon as you can, rather than languishing on workers' compensation or perhaps other kinds of benefits. That in the long haul, it's better for you psychologically, it's better for you financially, it's better for your family to get back into the workplace and have all the things that go along with work available to you. So you have everybody in the system in this state really dedicated to that, from labor leaders to businesses that have light work policies and so on, to the provider community that is very dedicated to trying to get people back into work as fast as possible. And then lastly, I'd say that one of the features that that is very important to all of this is the balanced policymaking process that they established when they created the program, and that has held up to this day. And that's really the Workers' Compensation Advisory Council. And back in 1911, they set this up with equal numbers of labor and management representatives. And the idea was that they would look at whatever changes were potentially needed in the program and work out their differences and reach an agreement. And it would be only those agreed on pieces of legislation that the legislature would pass. And of course, this requires the cooperation of the legislature to make this happen as well. That process has really maintained to this day and is, I think, really an important part of why we've had a successful program, especially in our state. In that process, we get a lot of input from the insurance industry. They're at the table, non-voting members, but they provide input. We get a lot of input from healthcare providers because they're intimately involved in the system. We get a lot of input from attorneys representing applicants as well as employers. But at the end of the day, it's labor and management really at the table voting and agreeing to whatever policy changes would be considered. We obviously listen to what legislators want. We take input from the general public. And we then engage in really a form of bargaining, like collective bargaining, where we kind of exchange proposals and go back and forth, and at the end of the day, finally, hopefully, reach an agreement that can be put in front of the legislature. This all works because the legislature lets it work. There's no way to control them other than maybe put something in the Constitution, which we don't have. And remarkably, they've adhered to this for 100 years essentially, with few exceptions, have not passed any other workers' compensation laws in our state, except those recommended by the council. And that, I think, has really created a situation where we've had a very sort of stable program, a very stable set of policies. It can be frustrating, you want to accomplish X, Y, or Z, or Ron and his constituents want something, and we won't agree to it, or they won't agree to our stuff, and we don't get it done. But at the end of the day, it means that only modest incremental change occurs, and that has really served the program, I think, particularly well. I've been part of this process for a long time. I've worked with a lot of very talented people who know a lot more about workers' compensation than I do. But it is really a remarkable bit of policymaking and a real testament to the endurance of this program. We do have some current challenges, issues that are we're wrestling with, I guess, today. There's always challenges to the exclusive remedy. Those are usually fought in court, and for their part, the court system in our state, the Supreme Court, has generally upheld the exclusive remedy, and I think that that's to their credit, and in recognition of they understand what this program is about and how it works. We're trying to wrestle with rising healthcare costs in the system. We don't have a lot of utilization, but for the services that are provided, they charge a little more here than in most places, and we're trying to figure out how to deal with that. Litigation rates, we've always tried to keep that, the transaction costs low to make the system accessible to everybody without lawyers. That's always a challenge, and I think, we continue to wrestle with those issues. There are issues of independent contractor. Individuals, if they're not employed, don't have to have workers' compensation coverage. So as an independent contractor, if you're, a sole proprietor and you do some kind of service, you don't have to buy an insurance policy for yourself. Every other employer must have workers' compensation insurance for every one of their employees. It's a matter of law. There are steep fines and such for those that don't. But what happens in the independent contractor area is in industries where it's very expensive insurance, like cutting trees, for example, the logging industry, they've almost organized themselves completely as independent contractors to avoid having to have the insurance. And here they are in an industry where injuries are very common and they're without coverage, and it is an issue that we need to address. There's issues of permanent total disability. Some people are injured so severely that they're permanently, they are declared permanently and totally disabled. They get benefits virtually for the rest of their life. But we don't have a good system for keeping the level of those benefits current. There are issues surrounding, how you define that, and I think there's a lot of concerns about labeling anybody permanently and totally disabled, especially in light of, the sort of countervailing force of the Americans with Disabilities Act, where you've got people who are disabled fighting to get into the workplace, and then, over here we've got other people that were saying, no, you're done working, you're not going to have to work for the rest of your life. So those are issues that need to be addressed. We have, a very changing sort of nature of work in our state in one sense, and this is probably not widely perceived, but the rise of the so-called staffing industry or the professional employment organization. There are companies that will become the employer of all of another company's employees for the purposes of all of the human resources stuff. So they take care of the payroll, they take care of the workers' comp, they take care of the unemployment compensation. You still manage them and have them do the work that they normally do, but you're technically not their employer. Well, those are very different relationships, and they created a lot of havoc in the law, and we've had to sort of continuously work on addressing that and are continuing to do so. And lastly, I'd say that just trying to nurture this agreed-on bill process and keep the legislature from going around it and meddling and doing things that might be more extreme than the council would ever agree to. And by that I mean, it would be not unusual for a Republican-controlled legislature to be looking at things that might be more favorable to business and passing, their natural tendency would be to pass bills that would, favor business. And the Democrats in the legislature, when they're running both houses, would be perhaps more favorable to the interests of labor. And what you would have if you didn't have this council process kind of moderating that is really kind of wide swings in policy that would occur as you had the shifting control of the legislature. 2 years ago, Democrats controlled both houses in the East Wing. Now Republicans control both houses in the East Wing. So I think you can see what would happen. So this has really served, I think, the state very well, this process, and we're constantly trying to work to maintain it. Overall, you know, it's a great system. I think it provides a very important societal benefit at a fairly reasonable cost to employers, and it's a balanced system that I think has benefits for both sides, and you don't really find that so often in public policy choices or, great social programs that are created. And so it's really an interesting model, and I think it's something that we have a wonderful connection to in our state, and certainly the folks here in Wausau with the long history. And now we're going to get a chance to hear from Ron, who's a real historian of the program. So do you want me to just turn it over to Ron? Thank you.
And I want to apologize. Ron Ken is next, the retired ASME educator. I still don't know how to use cut and paste successfully, so sorry I introduced them out of order, but Ron is next, so go ahead, Ron.
Okay, thank you. All right. Well, thank you for having this wonderful forum. I appreciate being here, representing labor and also the Worker Compensation Advisory Council, where James and I both served together. And I must say I have the honor and privilege of serving with him for the last almost 8 years. And must say that as a labor person to a management person, I must say your integrity and your work has been well appreciated on the labor side. We appreciate all your work. And I want to thank the university for sponsoring this forum today as well. I want to spend a little time today giving you a little history. I am myself an historian as well, and I wanted to give you a little background on where the origins of worker compensation come from. The first worker compensation system that we know of in history was actually established by the Prussian government under Frederick II as early as 1776 for coal miners in Prussia. And it was known as the Clevisch-Märkische Beordnung. And it was set up as a holistic way to pay injured coal miners for injuries on the job. And that included permanent disability as well, and medical care. There was no old age provisions in the law, but it did cover injuries. So Frederick the Great was an innovator. This idea existed in Prussia for many years. It took many different forms in subsequent regimes of that particular part of Germany. And it's important to know that this informed the work of Bismarck as he adopted some of these ideas at the urging of Gustav Schmoller, who were part of the group of the Cathedra Socialisten, which would be cathedral socialists. They would be considered today fairly conservative socialists, state socialists, who urged the chancellor to employ a system whereby injured workers would be covered for their particular accidents at work. And after many years of lobbying by the Verein für Sozialpolitik, which was a very large group of economists in Prussia, this particular idea gained some traction and also interested the Kaiser as well. So what is interesting about this history is that this became a model for other countries. England adopted its early worker compensation system as early as 1894 and 1897 through the work of people like Joseph Chamberlain, who worked with the British government to set up some of the first British law that covered injured workers. So these two systems really kind of competed with one another. The Germans were always sending economists over to England, and the English were sending economists over to Germany to see what kinds of systems they would employ. And some of the aspects of their systems are quite different. The Germans, for example, did not cover diseases, whereas the English system did. The English system also had different kinds of roles for appeals. They allowed litigation, whereas the German system did not. And compensation in the German system for all injuries caused by accident was overseen by a very large the Imperial Insurance Office. And they would hold hearings, and if they felt the workers' particular injury did not qualify, they would deny the benefits. So it was a stricter system, more narrowly applied than the British. The British still allowed for litigation. Under the German system, there was arbitration. And also the Imperial Office would often issue rulings that would be binding on workers. So as a consequence, you had two competing ideas. And when John R. Commons and his associates at the University of Wisconsin in Madison and Charles McCarthy started looking at these systems and studying them, and by the way, their students helped them a great deal in this area, they adopted some of the ideas for Wisconsin. And some of these ideas today are enshrined in our law. And a few of them to bring to mind was the idea of covering diseases. Diseases are covered under Wisconsin law today. The idea of illness, the idea of mental and physical injury is covered. So a lot of these early ideas found their way into the Wisconsin statute over the years. The original idea, of course, of having a system that Commons and McCarthy put together was a great innovation that was shepherded through the legislature by Governor Francis McGovern, a Republican, by the way, a progressive Republican, who shepherded a number of other innovative ideas such as shared revenue and so forth. And those ideas were very, very helpful to the state of Wisconsin, are still with us today. So I think these early ideas played a large role in the thinking also of the labor people who were the first ones really to introduce the bills into the Wisconsin legislature as early as 1894. Frederick Brockhausen and Frank Weber. Frank Weber was the head of the American Federation of Labor, which was founded in Wisconsin in 1893. Frederick Brockhausen was a German worker who had fled Germany and come to Milwaukee and settled there and be active in the Social Democratic Party of Wisconsin, which was formed as a separate party in Wisconsin, later became the Socialist Party in 1901. But they brought with them their ideas to mollify and also to modify legislation to help injured workers. And they were very concerned about making the law something where the workers could sue still, and in some cases they still wanted more policies favoring workers. It is called the Great Compromise because they had to give up some of those ideas in order to get a bill passed. And they learned very hard, in the hard way, because the early bills that had been tried by labor as early as 1902 in Montana were declared unconstitutional by the courts because they were compulsory. And because of the nature of compulsion, the courts were not inclined to let these laws stand. And this is true in Wisconsin as well. There were a number of laws that were tried in Wisconsin in the early 1900s, including pension laws for teachers that were declared unconstitutional. And it wasn't until 1911 that teachers woke up to the fact that they have to make their pension system voluntary and not compulsory. And that's how they won the statewide teacher pension law. But that's another story for another day. The worker compensation had the same kind of issues covering over it. And Commons was well aware of the court's reluctance to impose a system of compulsion on employers. So he wrote the bill, along with Charles McCarthy, I think, with that in mind. Learning from the German example and the English examples, taking some ideas from their systems. The labor people were really, really in favor of the British system, unfortunately, but the British system actually paid less. The Germans paid more money to injured workers, about 2/3 of their pay. So it was a more generous system in some regards. However, at the end of the day, the labor leaders got together and they realized that in order to pass this bill in the legislature, that they would have to trim their sails and try to look at a bill that was more realistic and that could be amended in the future if it was upheld as constitutional. So this was the great thinking of Frank Weber and Frederick Brockhausen and the business community that went along with them and helped forge the bill and shepherd it through the legislature. And as a result, Francis McGovern signed the law on May the 3rd, 1911. It was held to be constitutional subsequently. And by the way, the Supreme Court of the United States in 1917 upheld Wisconsin, and a number of other statutes had been passed from a challenge to the U.S. Supreme Court itself. So the Wisconsin model of voluntarism, of the idea of covering workers who were injured, taking away the idea of suing your employer in exchange for getting an indemnity payment, which is a payment of money to sustain the worker, and covering all medical costs, which is very substantial in our law. And as James mentioned, is still one of our issues that we're trying to study and grapple with today. From the labor side, this council has operated well, as James remarked earlier. We've had a balance. We've had many, many contentious sessions, but at the end of the day, we put aside our differences and we come up with a compromise that has worked well in Wisconsin. We still have ways to go. We still need to improve the indemnity payments of permanently total disabled workers. James mentioned also medical care. We need to grapple with that, how to control those costs. And we need to look for ways to improve the law in other areas for insurance of the family and children of injured workers who may lose their coverages because they are long-term injured workers who no longer have coverage with the company. So those issues still stand before us, and we welcome, of course, your input into that process. The Council is an open public body, and we urge you to participate with it and give us your ideas and your best thoughts, because these help us make the law stronger in the end. At the end of the day, the Council is an advisory council to the legislature, and the advice that we get from our citizens as well as from our constituent groups is very critical in making our law successful in helping injured workers. Thank you for your attention.
And again, next is John Jones, retired Senior Vice President for Nationwide.
Yeah, just when I thought I was free, Brad Zweck dragged me back. It's really a pleasure to be here, dusting off some of the recollections of my so-so career. I wanted to chat with you just briefly to supplement a little of the conversation about the Advisory Council. A, it's really unique because B, it has an established record of success. In my younger days with WASA, I tramped the 48 states trying to work with local constituents on how to improve a failing workers' compensation system. Generally, my advice and the advice of other insurance carpetbaggers was not well received. But the industry was struggling with states who could not get their act together for a sufficient period of time to provide any stability for workers, for insurers, for employers to have a system that would run as well as the state of Wisconsin's workers' compensation system. I had an opportunity to participate in the Advisory Council process from 1980 to 1992 as one of 3 non-voting, let's emphasize that, non-voting insurance representatives. And our task was really summarized in one word: listen. It's important to understand the interplay between labor and management. It's important to understand that you're a non-voting guest in this process, but an important resource if they want to touch that resource. and to provide an opportunity for a sharing of experiences in what other states were attempting to do in failing workers' compensation programs. So I titled this subset of my presentation, Walking the Line as an Insurance Representative at the Advisory Council. As I mentioned, there are 3 non-voting members of the council. These representatives bring actual street experience to the identification of issues which can or should receive council attention. We work and should work with both constituencies, labor and management, to identify these issues and to watch and listen to the process as it is debated. Some of the experiences that I tried to bring to the council were experiences I had drawn from other state failures. There was a way to describe the legislative climate back then in workers' compensation countrywide as, in many states, crisis, reform, and crisis. A crisis drove reform that was ill-conceived, not thoroughly thought out, probably the result of a political party's view at the time that they were in power as to how to correct the situation. If there's one thing that you can take back with you from this presentation today about Wisconsin Workers' Compensation Act, its illustrious history, is that over time it has adjusted to changes without propelling itself into a crisis, reform, crisis mode where there really are no long-term winners, because you're right back at it a few months later, maybe a couple of years later, trying to correct things that should have been dealt with initially. One of my most interesting experiences on the Advisory Council might start out like one of my few war stories in litigation, but it went something like this. We could see from the insurer point of view that medical costs back in the early 80s were really skyrocketing. And we had a problem because workers' compensation fee-for-service medicine payer. There are no, at that time, schedules or ways to trim expenses based on any data that was being shared or any other true cost containment strategies. So we invited the State Medical Society representative, a West Bend physician, orthopedic physician, and he brought several other doctors with him to the session. And I had the opportunity to ask a couple of questions before it was opened up to the remainder of the group. So I thought I'd throw this one out. Doctor, isn't it a fair statement to say that since your costs are being controlled on the group side and the non-industrial side, that you're actually passing those costs on to workers' compensation? I didn't expect this answer. Yes. Doctor, are you sure you understood the question? He said, not only do I do that in my practice, but other physicians that I know of do as well. And I was smart enough not to ask any other questions. That is remarkable in and of itself. But that simple answer to the question triggered an immediate response that, although it took a while to kindle the opportunity to get a fee schedule into workers' compensation, and it was beyond my term at the Advisory Council, they have succeeded. A most recent study by the Workers' Compensation Research Institute, an organization I'll talk about briefly at the end of my remarks, indicates that utilization in Wisconsin is down for medical services provided by hospitals, but the costs are going up. So we need to always keep our thumb on the pulse of this system, the medical, the indemnity, the opportunity to be timely, bringing disputes to resolution before administrative law judges. This is just simply another touch point in the process of workers' compensation that we as members, former members of the Advisory Council, present members of the Advisory Council, and the general public need to understand. It's a system that moves along and generally performs rather well. And when it doesn't, we owe it to those people who work on the advisory council to share with them our concerns and let them hammer out the result. So my advice that I learned the hard way in the workers' compensation process is when you're at the advisory council as a non-voter, shut up and listen. Try to work effectively with both management and labor. Work to make that agreed bill a positive opportunity to influence a system with a renowned reputation. The state of Wisconsin has been fortunate enough to avoid a crisis correction environment in workers' compensation. Our injured workers have benefited from that. Our insurance companies have benefited from that. Our employers have benefited from that. It's an interesting process to observe, and I learned a great deal when I listened. I'd like to talk to you about something that's near and dear to me, the Workers' Compensation Research Institute. It's housed in Boston, and in the interest of full disclosure, and the foundation of this is rather simple. After the radio program where we introduced what we were going to do today, and we had brief opportunity to speak on public radio for about a 1 hour period, we certainly didn't talk that long, but in any event, apparently my daughter decided to Google John H. Jones Jr. I've never done it. I didn't think I really needed to be honest with you. I kind of lived that life. But in any event, she discovered and brought to my attention, Dad, why didn't you ever tell us that they offer a $10,000 research grant each and every year in your name? Well, I'd forgotten all about it. But that's what you have to be cautioned about. Okay, that's my potential conflict, that I may not see too clearly on this subject or speak as accurately as I perhaps should. Having said that, in 1980, a group of trade organizations decided they needed an institute to step off to the side, research some of the cost drivers in comp, and bring in some research that you can go into the states and lobby. Well, let me tell you, I was unalterably opposed to that idea. What we needed to do was more money for government affairs, get in there, we can convince them we're honest people, and we know we're from Wisconsin, we understand, just take a look at our great act, you'll love it. Folks, what happens in Wisconsin in workers' compensation is not readily transferable. They try it in the state of Minnesota periodically by ripping the cover off our Wisconsin Workers' Compensation Act, putting a Minnesota cover on and trying to get it passed. I'm not kidding you. They've actually done that, but failed. So I was of the opinion that there was no bigger waste of time in developing an institute to research these issues, because the barn is on fire and we need to put out the fire. It will take years before an organization will have enough credibility to publicize research on this very weighty subject. Well, brighter guys than myself cornered me one day and said, you're going to interview the candidate for this Workers' Compensation Research Institute job position. And at that time, I met Dr. Rick Victor, and let me tell you, he's a fast draw. Fantastic intellect, really was interested in applying himself to this task. I was immediately suspicious because he was working at the Rand Institute, and why would anybody want to leave California for Boston? But he wanted to. So the Workers' Compensation Research Institute has generated the following types of research. I'm not going to bore you to tears with the details. Number one, administrative inventories. How in the world does this particular state administer workers' comp? They've done that in a number of states, including Wisconsin. I think you'd find it a good read. Number two, their whole research orientation of late has been, we can control the variables of our research, and we can now do state comparisons on a variety of issues. And you can actually peg state performance in terms of their peers, the other states, and the particular issue that they want to track. And finally, the third aspect of their research program is in the field of medical, trying to find out what works and what doesn't in controlling medical costs and workers' compensation. It's important to remember that the work of the Institute is the work of the Institute. They do not lobby, they do not make recommendations, they do not render their opinions on up or down. They allow the readers of the research to draw their own conclusions and use it in the debate to improve workers' compensation systems throughout the country. Just shows you how wrong I was again. Thank you for your time, and thank you for the invitation to participate. I've really enjoyed it.
And Professor Kirsten.
Good evening. I would like to thank Brett and Eric and Connie for their warm welcome. I'd like to thank our absent friend, Jim, who I understand is recovering. And I'd like to thank my co-panelists. It's an honor to be with you tonight. And it's an honor to be with people who shape public policy, and I appreciate your work. And it's also an honor to be with my fellow historians. We're a little top-heavy on the historians here. Of course, I think that's good. I'm also mindful that I'm the last thing between you and cake. So I thought I'd be a little bit brief. The progressive era stands in stark contrast to our own. For a time, Wisconsin was internationally known for its commitment to forward-thinking laws and policies that helped average workers and average families cope with modern life, particularly the modern industrial system. We cannot underestimate the carnage reaped by American farms and factories at the turn of the 20th century. And statistics tell one tale, and I'm going to give you one a little bit out of this period, but it's one that I know in some detail. During the first 3 years of the Second World War, more Americans were injured and lost their lives working on the home front in factories than were killed fighting on the battlefronts. In my own extended family, there are many stories about serious injuries and deaths in the factories, and I suspect there are many stories just like that here tonight. But the question before us is this: how did Wisconsinites deal with worker accidents? How did Wisconsinites use government to improve their lives, and significantly, why? Why do that? And so let's get through a simple matter first. And it's been explained before, but let's give some common ground here. Wisconsin's Workmen's Compensation Law of 1911 removed employers' legal protections in court. And there are 3 big ones. We can talk about them later if you'd like, involving workplace injuries. And then the state set up an insurance system whereby injured workers gave up their right to sue their employers over accidents in exchange for payment compensating them for their misfortune. The final bill was a compromise. Employers took on the burden of funding the system, and workers had to agree to the system at the time of their employment before they were injured. And now for the meaningful historical question. Why? Why did workers and employers fashion this progressive solution? And why did Wisconsin progressive politicians champion it? To answer that question, one needs to understand 3 things about Wisconsin's history. Thing 1, there was a major conflict between workers and employers at the turn of the 20th century. Thing 2, this conflict transformed state politics. And thing 3, progressivism in the state was a middle ground. And by the way, I'm implying here we're misusing the word progressive in our political language. Was a middle ground between left and right. So let me explain the context in further detail. The fight between labor and capital was quite intense and at times quite violent at the turn of the 20th century and in the late 19th century. There were spectacular events, such as the Bayview Massacre. There were big strikes, like the General Strike in Oshkosh in 1898, and thousands of smaller strikes and protests and pickets throughout the early part of the 20th century. The union movement in Wisconsin was at its root a movement of workers to defend their interests at their places of employment, and at the seats of political power. And one major goal of the Wisconsin State Federation of Labor, which represented thousands of workers in various unions, was worker compensation. Beginning in 1905, when Wisconsin citizens sent their first socialist to the state legislature in Madison, legislators who represented unions and workers began to introduce worker compensation bills. At first, nearly all this political activity was on the left. Social Democrats, and they're already mentioned the two big ones, Fred Brauchhauser and Frank Weber, were leading members of that Milwaukee-based, labor union-supporting, mostly German members, German political party members who pushed hard in Milwaukee and elsewhere for laws that helped average people. Within a decade and a half, the socialists in Wisconsin had gained quite a bit of ground, especially in Madison. For the 1919-1920 legislative session, there were 20 socialists, 16 in the Assembly and 4 in the Senate. In 1911, there were 14, 12 in the Assembly and 2 in the Senate, and they pushed hard for laws and reforms that would benefit workers. In that 1911 session, which one might call, if you allow me to coin a phrase, and there's probably no stopping me now, the Great Labor Session, there were over 1,000 bills proposed, many of them aimed at improving the lives of average workers. Some significant laws resulted, including this worker compensation law, but there were others too that were passed that established new state-mandated safety standards, the limits on the hours that women could work, we could talk about that later as well, and a new child labor law, as well as a very interesting law putting limits on employers when they were advertising for jobs. Now, understanding the grassroots socialist movement in Wisconsin is vital to the passage our understanding of this passage of the worker compensation law. Conservatives in both the Republican and Democratic parties dismissed the socialists out of hand, but they begrudgingly listened to those politicians in the middle known as progressives. Outside of Milwaukee and some other locations, the progressives seemed very viable alternatives to Gilded Age politics, which ignored the needs of workers and their families. Progressives like Governor Francis McGovern, who signed the Worker Compensation Bill into law in 1911, believed that he believed in capitalism, as all progressives did, but also believed, quote, that economic forces must be regulated as to secure a fair chance for all in every walk of life. So, as the state encouraged capitalist development, it would also, quoting McGovern again, quote, afford the weak, the unselfish, and the defenseless equal chance in the race of life. In terms of worker compensation, McGovern advocated, quote, last quote for you tonight, a more enlightened and humane system of compensating workmen injured in the course of their employment. That's the way progressives talked. They were in the middle. In addition to having moderate reformers on their side, Social Democrats also got traction with the worker compensation bill because employers had grown tired with the existing system. Not all employers offered worker compensation, although many did, and 6 out of every 10 claims were often booted out by the insurance companies. And what employers were finding is they were paying premiums and to insurance companies, and the companies were never paying out. This made them upset. The second thing that worried them is that for the companies that didn't offer any kind of worker compensation, employees that were injured began to sue. Most of the time they lost in court. Every once in a while they won. And increasingly, in the turn of the 20th century, the legal settlements, the judgments, were growing in size. And what capitalists wanted in the state at the turn of the 20th century, just like today, are regular expenses, so they can help predict the future. The workman compensation system that Wisconsin progressives fashioned provided that regularity and rationalized costs of injuries. Finally, the best minds in the state, such as John R. Commons of the University of Wisconsin, encouraged his friends in industry, and he had lots of them, to support the worker compensation legislation. And despite its political origins in that grassroots socialist movement in the state, Commons played down the idea that it was a radical panacea. Rather, it was a way to achieve financial efficiency as well as social balance and harmony. The worker compensation law passed in 1911 then was a compromise. Workers had to agree to it before they were employed, and companies lost their common law defenses in court if they chose not to join. Eventually, in 1931, the system became compulsory for everyone. Those were the kinds of deals progressives cut in order to humanize the industrial system, and Wisconsin led the nation. Sometimes people refer to lawmaking as sausage making, a phrase I really don't like. Our butchery became known as the Great Laboratory for Reform. Thank you.
Okay. Well, thank you again, everyone on the panel. What we would like to do is, first of all, I'd like to ask, does anybody on the panel care to comment on anyone else's? Did anything come up that you'd like to discuss or amplify or rebut, or can we move straight to questions? How do you feel? Think we can go to questions? All right. Well, what we're going to do is there will be a couple of people in the audience with microphones, a couple of our helpers who will come and bring a microphone to you. We'd ask you wait until the microphone arrives to ask your questions so that everyone can hear and it can be recorded. So if anyone has a question or a comment, if you'd raise your hand, Ian or Eric will come and find you with a microphone. I know the cake is alluring, but someone must have one question. Is there in the aisle way? Yes.
My question, and the professors should maybe answer it, is I didn't hear any conversation about how proven the workers' compensation system from a cost-benefit situation has been compared to other social delivery systems. I'd like to have them comment on that.
Would anybody like to jump in on that one?
I'll take a shot at that. I think your alternative is a litigation system. And those systems generally don't produce good results because, number one, you have a tendency, as James and other panelists point out, for wide swings in the jury awards. You also have no way of predicting how juries are going to find either for the company or the employee or the employer. With worker comp, you have several things going on. You have definite benefits that are paid out, indemnity benefits, definite medical care. The employer knows that they won't be sued, so that they are in a position to stabilize costs, which could inure to the firm in a different way if you had litigation. If you have litigation, the company could be wiped out by one jury award. It's very easy to do that. And you can see that in some lawsuits that are done in other areas of tort. In most countries, by the way, in the world, employ a similar type system, or they have systems that are very similar. They all vary. England, Germany, France, Spain, all the European countries, Scandinavian countries use a similar type system of worker compensation where indemnity payments are paid out to workers. The Netherlands has a very simple system whereby the worker gets 80% of his pay regardless of whether he's injured at work or home, and all his medical costs are paid. And they administer a very simple system whereby the worker is encouraged to go back to work, but the benefits are substantial and the stabilization is great in the economy. Employers know that what the costs are. Costs are definite, they're not indefinite. And so otherwise you have a kind of an anarchistic system that can result in very, very severe costs. And this actually happened in Germany. Under the German system in the early times, they found that the laissez-faire way of doing it, let everything be decided by the market, didn't work well. Firms would have injured workers, and then the workers would become disgruntled, and there was social unrest. And we can go back in German history and look at
some of that social unrest, the weavers' strike as early as 1844, and other uprisings throughout Germany were quite bloody. And so the other social effects of not having social insurance was well known in Germany. And Bismarck was not exactly what I would call a liberal. He understood that in order to have this system, he was also trying to stabilize the society in some way to prevent other kinds of eruptions from happening, and also to make sure that business had a good climate, that the small businesses that existed in Germany would be stabilized. So, and the farms, etc. And the workers could expect certain benefits in medical care. So it became a stabilization factor on many, many levels. And you find this in most systems that have worker comp. Canada as well has a good system whereby people are taken care of in a very comprehensive manner. The alternative, I think, is a very, very bad alternative, which is litigation and I would say social unrest and other kinds of factors that would ensue. It would be very, very disruptive to the economies of many countries not to have something like this. And I think this is what the original thinking went into the establishment of worker compensation as a social insurance program, along with other kinds of programs that were instituted by European countries and then are slowly also been implemented in our own country with Social Security and Medicare and Medicaid. Similar social kinds of legislation became acceptable to also have definite costs, but also to make sure there were definite outcomes, medical and otherwise, that would not be harmful to the individual or to society.
Ron, you said social unrest in Germany a little close together for my comfort. So we're going to see if, did James, did you want to jump in there?
Sure. Yeah. Directly, I don't think I've ever seen a study that tried to quantify what the alternative would cost versus what workers' compensation costs. And it might be a fruitful topic for the WCRI, the Workers' Compensation Research Institute, at some point. But maybe you can draw some conclusions from what happened during the period of time when the program was voluntary, from its inception till the early 30s. There was widespread, flocking to the program. I mean, on the part of employers and employees. I mean, people saw it as a better alternative, presumably, having done some financial analysis from an employer standpoint anyway. The tort exposure today would probably be worse in some respects. I mean, I think, arguably we've got more lawyers who, have more history, more case laws built up over time, and I don't know. What Ron's talking about is sort of the alternative of that, where if somebody is injured but doesn't make their tort claim succeed, what do you do with them? And I think in our society we would have some other program to take care of them anyway. I mean, you aren't just going to let people, languish without some kind of a safety net. So there would be costs associated with that, I think, anyway. So this system has elements of it that I think work to moderate costs, one of which is the fact that it's a private insurance program as opposed to a government benefit stream. I think that has served us well. And it's an interesting question that I've never heard asked before, which maybe says something about it too. I don't exactly know what to make of that, but...
Okay, there's a question here in the aisle. Just a minute, they're coming with a microphone. There you go.
The panelist mentioned a couple of strategies that were used to control cost, physician fee schedules, return to work. What's the today's opportunity to help control workers' comp costs?
Well, one of the features of the system has been free choice on the part of the injured worker to choose their medical provider. And, I think it's something that employee representatives, think is an important thing to control or to have. But that has minimized the ability of traditional means of controlling healthcare costs, so-called managed care, to be utilized in the workers' compensation system. One idea that we've we're pushing presently is to allow employers to direct care for the first 90 days or so, and ultimately leave it to free choice. If you somehow think you're not getting good care, you ultimately would be able to go elsewhere. But that would give you would create an environment where, you know, an insurer or a large employer could start to negotiate rates with providers and get some discounts and that sort of thing. The fear, I think, on the part of the employee reps is that, you know, that some employers will unscrupulously direct you to sort of substandard care and you know, docs that, you know, never saw a patient that was injured by anything. And that, you know, sadly, that potential exists. You know, I mean, I think there's always somebody out there that's going to be on the fringe and do something wrong. So somehow we've got to resolve all of that. But that's at least one way of dealing with the issue.
Okay. Yes. Wait a minute. Oh, did you want to jump in real quickly?
Yeah.
Go ahead. Go ahead. And then you'll be next. Go ahead.
Yeah. As James points out, that medical costs are a key driver, and we're trying to deal with that through working through a system whereby we have guidelines now, and we've also modified the standard deviation in the law to allow for payments to be ratcheted down somewhat for these outlier charges. It used to be in the law that, as was mentioned earlier, that they could charge anything they want. They are limited now by a standard deviation in the law that it cannot exceed the standard deviation from the mean. So a doctor cannot charge way wacky prices way out from the mean for a procedure. So that's one thing we're looking at, is whether we can lower that again, or that's another thing that's in our discussions right now. The medical providers, of course, are not happy with that possibility, but given that the medical cost drivers are going up and up, we have to get a handle on it, and I agree with James. So we have to look at some alternatives. I'm not sure if it's the one that James mentioned, but we've looked at a number, and we're still going to be studying this issue, is how to control medical costs. One proposal that was before the council a session or two ago was to control medical costs by using freezing databases, which sometimes are proprietary. It's hard to get these systems that have proprietary databases to give up their data, and so that we know what people are charging. But once the databases could be made public, and then what we wanted to do was freeze them in a certain year, and then only increase them by the medical cost of living. So therefore, you would have a control of the cost. You would not have a super control, but you would prevent people from gaming the system somewhat. So that, to me, still is a idea that ought to be looked into further. Would require us getting databases and doing a lot of work with the department to develop the staff to have that happen in the state. It's not easy to administer either, and I admit that, but I think we've got to keep looking into that as an issue to control costs. We're also looking at ways to make sure that the law is enforced carefully, and the cost drivers, whatever they are, especially the Wisconsin system, don't wreck the good medical care we have. We have an 85% approval rating of our doctors in worker comp. That's a very high rate of approval. And a lot of injured workers find the doctors to be outstanding. We have very little dissatisfaction. So we don't want to drive doctors out of the field, as happened in Texas, where they made a system of Medicare plus, I think, 50% or whatever it was, an awful idea. And they drove 1/3 of the physicians who were practicing worker comp medicine out of the field. So I don't think that's a good way to control your cost drivers. You drive the doctors away who are providing good care, you end up with the doctors who maybe don't want to be practicing worker comp and getting paid very poorly. So there has to be a kind of a grand compromise here as well, and we have to look at ways to control the cost. But we are looking into it seriously, and I share James's concern that There has to be what has to be looked at are the medical side, because that's one of the biggest drivers of our costs right now.
And
and we're looking into it seriously, as well as some other areas.
James dying to get back in,
Sure,
so
no,
go ahead.
Just to make an observation is that most states have employed a medical fee schedule. They basically, I mean, oftentimes it works off the Medicaid reimbursement rate for medical procedures. Other times it's made up separately, but it literally it says nobody can charge more than X for a given medical procedure. And that's not a very free market approach to this sort of thing. But it's employed because we don't have the other tools typically in a workers' comp system like managed care. And so that's the dilemma, is how do you do this under these unusual circumstances? What those fee schedules look like, I mean, some of them are, as Ron said, very tight. I mean, Medicaid reimbursement levels vary by state, but in some states like Wisconsin, they're quite low. And, you could have it be Medicaid plus 200% or something and have it be a fairly high reimbursement rate. The providers really balk at all that, though. I mean, they don't want to be limited, and so we have to sort out all of that as well. But, yeah, it's clearly a big issue, and we don't have we probably have less going on here in medical cost containment than most other states. And we've been somewhat insulated from, this being a bigger problem by the fact that we have low utilization rates. In other words, they're not overdoing it in terms of the numbers of procedures. They're just charging a lot for the ones they do provide.
Okay, and a question down front.
In the 1950s, I worked in the claim department at Employers Mutuals, and as I recall, what we referred to it as was workmen's compensation. And I just wondered if women were included from the beginning, or was that a later thing, or was it just industrial and not including women, or what?
Women were included as long as they were working, and were never excluded as a covered group as long as they were working. Where they were excluded was from some of the early legislation, for example, limiting women's role in night work or other kinds of dangerous occupations. There were laws on the books in many countries, including our own, that restricted that somewhat. But women were, as a group, where they worked, were always part of the mix and part of the coverage in the law. They were never meant to be excluded whatsoever. In the current law, too, we have provisions for minors, illegal employment of minors, and that's dealt with in the statute right now to prevent employers from exploiting minors unnecessarily. And then when those minors are injured seriously at work, they do get benefits, but the employers get fined for doing those kinds of illegal actions and hiring underage children, for example, for work. But women were always part of the covered universe, and I don't think they were ever excluded.
Just, I think it was an age of gender-specific language where workman was just considered, right? It was a different age and different terminology. I think that's right. Question over here in the aisle. Just a minute. Oh, wait a minute. I'm sorry. You were first. I'm sorry. We'll get to you next. Yeah.
In the age when businesses are trying to become more efficient by encouraging fewer employees to do more work and to do it in a limited period of time, has there been some of the work-related repetitive injuries?
Could you just state that last part one more time? What kind of injuries?
Injuries that are characteristic of being connected with work. 20 years ago or so, you found nurses and CNAs with bad backs. Well, you no longer find that because they're not injuring their back at work. They're using lifts to move patients. But in today's industries, a lot of businesses are trying to get fewer employees to do more work in the same time. So are you finding some of these repetitive injuries like carpal tunnel or shoulder injuries or things like this?
You're probably right. But as a general observation, the number of sort of work-related injuries has been steadily declining, and the seriousness has been declining. Number of workplace deaths has been declining, and the number one cause of workplace deaths is car accidents, and the second one I think is gunshot, which is a result of people working in convenience stores. So it's not the industrial accidents so much anymore as it used to be. But yeah, repetitive motion injuries that's a very common type of claim these days, much more so than probably it used to be. But the general seriousness of injuries has definitely declined, and as a result, the indemnity side of what the system covers, has really not been where the growth is. It's all been on the healthcare side, and not so much because there's more claims, but because the healthcare cost of treating the injuries has been going up.
Maybe we could ask Andy this too, but it's also partly the nature of American work that's changed over the last 100 years as well, right? Which probably has influenced workers' comp.
Absolutely. As the nature of the industrial era has moved into a post-industrial era, you get a different set of injuries, carpal tunnel being one, back injuries from lifting things if you work at a big box company or something like that. Also stress-related injuries as employers have also adopted a new regimen of how they work their employees, working them a little longer. Trying to hire younger workers has also created a certain kind of injury as well. But I also like to say some of those injuries, so the sort of manual labor, the physical labor in the workplace, I think has increased in some regards, even down to working on computers, which is highly stressful. But in this period of the turn of the 20th century, there are a lot of remedies that employers could use to improve their workplace. They could begin, and they did begin to guard machinery so that belts and chains were now guarded and kept away from workers. And in addition, the labor unions pushed strongly for the introduction of hand devices to control machines. And so, for example, my wife's great-grandfather was maimed at a mattress factory as he would, I don't want to go into too much great detail, but he was caught inside one of the sewing presses. Workers, especially in unions, fought for hand devices to control that. And the purpose of the hand device was because if you're clicking the machine to go down, your hands are not there. And so they get rid of the foot treadles on machines. So it's a completely different kind of work environment that we live in now.
Interesting. Right here in the aisle? Yeah, go ahead.
Yes, James, you started off your remarks saying how people, apparently the individuals and the employers, gave up their rights for a grand plan that apparently collectively worked out very well. Perhaps some of that could be used today in the problems that we're having to people to come together on that. And I'd like to ask John Jones, you've been continental traveler, 48 states. What was the strength of Wisconsin's workers' comp compared to the other states?
Technology. I'm still struggling with.
Right in the middle.
Right, thanks. Technology. I'm still struggling with it. The reputation of Wisconsin's workers' compensation system is extraordinarily high. Now, if you ask certain states, they will say, well, it's an anomaly. It must be the milk they drink, the fresh air they breathe, what have you. But I've been on the stump on the issue of the Advisory Council for any number of years. I am extraordinarily impressed with the ability to tackle tough issues. It may take more than one particular legislative session to get it done, but particularly impressed with the ability to reach a common solution with each side generally giving up a little bit in the process. And in something that wasn't really mentioned, and something that comes to mind now about the success of the Advisory Council, a deal is a deal, and no one lobbies independently on behalf of an organization that's represented certainly at the Advisory Council about, well, we didn't get this, so we think you ought to, not throw your vote toward the Advisory Council agreed bill. And I've been really impressed both when I was working and in preparing for this presentation, that deal is a deal has not been disrupted in the current volatile government in Madison as we see. And I'd like to offer one other thought. I got a call before this program, and the caller will be rendered anonymous. But the caller wanted to know whether the advisory council process could work for other issues facing the state of Wisconsin. My enthusiasm was unbridled. Why, of course. I temper it as follows. I didn't say at the federal government level because I think we've seen so many commissions and study groups, and they report their findings and they're dead on arrival. But in Wisconsin, I think there is an opportunity to transplant this concept of an advisory council process, getting the stakeholders in a room with some expertise and a leader that has some skin in the game. In other words, a responsibility to report out whether or not an agreement can be reached or not. Is this particularly nebulous? You damn right it is, because I really can't give you a specific application for it. All I can tell you is I am enamored with the success of the advisory council process in the state of Wisconsin, and I've heard that process raved about in other states. I did receive one criticism once at a public session, and we'll leave the state unmentioned. And a gentleman said, well, isn't it true that advisory councils can only handle the little bitty issues and not really get involved? That's not true. I can give you a specific example. Way back in the era that I was still an active member on the advisory council, Milwaukee Circuit Court decision rendered an employer's refusal to rehire as a separate independent tort, which would have been a particular action outside the purview of workers' compensation. The advisory council had to deal with that issue, and it was contentious. But on both sides, they realized if this particular act becomes a separate independent tort around the exclusive remedy of workers' compensation, we're going to have a lot of litigation, a lot of expense, a lot of court time to try these issues where they best lie within the Wisconsin Workers' Compensation Act if we can get it there. Well, in the heat of a real debate, Leonard Zabrinsky, a lawyer representing the labor side, and I stepped out of the room. I think he was going for a smoke. When we came back, the advisory council had agreed that they were going to incorporate it in the act, and they were going to attach a penalty to that frivolous behavior by an employer. So about all I can brag about to my grandkids is I took a break at the right time.
Yeah, quickly, James, yeah.
Sure. I've been on this council for, I guess, 22 years. And I have the job of not only, kind of working on the council, but then I got to go over to the legislature and sell the product. And I've got a lot of experience with that. And it's really, that's the maybe untold part of the story. It really is very difficult to persuade the legislature to accept this because they're elected, by all of you to do the people's business down in Madison and vote on these bills. And, they say to you, who the heck elected you? Why am I supposed to, sublimate my opinions and my ideas to, this group of people? And why it works is because you have, a group like WMC that is, relatively influential with, many legislators, and you've got a group like the AFL-CIO that's influential with many other legislators, both standing shoulder to shoulder saying, with the people that listen to them, you've got to do this for the good of the order. And even when they're offering amendments that help your cause, you have to say no. I mean, we're going to fight this. And what I have found, the reason that we're able to sort of wield some influence in this is because employers buy into that idea. They like the idea that this is worked out compromise, even though they know they're not getting everything they want out of the system. They like the idea that we have a relatively stable system of policy making that doesn't have wide swings that result from changing political winds, and that helps me sell the guys I can sell it to, and it helps Phil Neuenfeld, who heads the AFL-CIO, sell it to his constituents in the legislature. But that part of the process is always tenuous and always difficult, and and always needs tending to. And we're having a particularly difficult time this time around, not so much with the workers' comp product, but more on the unemployment side, oddly enough, which has historically not been as contentious.
Well, on that relatively hopeful, if somewhat cautionary note, I'd like to thank everyone on the panel again and everyone for attending this evening. And if I could have your attention for just one more moment, I'd like to introduce UW-Marathon County's Dean and CEO of the campus, Keith Montgomery, who would like to make an announcement. Dean Montgomery.
Thank you very much. Thank you, Brett. I'd like to express my thanks to all the individuals and organizations who have helped bring this event about this evening, and also like to express my thanks to the panel for bringing their expertise and perspective. Thank you very much indeed. And I hope that you have enjoyed the program this evening, which is one of many that have been and will be hosted here at the UW Center for Civic Engagement. And I'm sure you'll agree that this is a beautiful facility, and it is a result of investment by governments and also by various private donors. And speaking of generous support from private donors, shortly after we adjourn to the lobby for a reception, we will honor a large donation given by John Carlin Sonnentag, and we will formally name the lobby area and adjacent meeting room Sonnentag Hall. So again, thank you. I will have a few more words to say about that later, but thank you for coming this evening, and please do join us for some cake.